Welcome to another episode of the Koffee Conversation Show powered by the Emerging India Forum, TEIF, and a tech partner, Prime Infotech Solution. Series is The Emerging Lawyer. Theme is Navigating Wealth Estate Planning Essentials. We have with us Advocate Sanjay Rego, a practicing lawyer at the Bombay High Court. Sanjay has a wealth of experience in wills, trust, family settlement, and wealth transfer. Join us as we delve into the significance of will making, the complexities of succession planning, and the steps necessary for effective wealth transfer. So, friends, I'm Lion Amir Virani, host at Koffee Conversation and legal tech evangelist at Prime Infotech Solution. So, Sanjay ji, welcome to today's special episode at the Koffee Conversation Show.
Yeah, thank you.
So I just wanted to explain you, Sanjay, our format. We have got 3 rounds. You must be aware of the 2, professional, personal. The 3rd round is a surprise rapid fire round, for which you get a gift also once you clear the rapid fire round. So let's begin. Okay. So Sanjay ji, how has the journey been till date in the legal world?
Okay. It was an interesting journey in the legal world because I started my career, as a chartered accountant, and then moved to the legal profession full scale in terms of doing work relating to personal law, trust related wills and family settlements. So I started off with having assisted the Universal Trustees, which was one of the premier trusteeship companies, independent trusteeship companies establishing family trusts for high net worth individuals and executorship of wills. And thereafter, I moved out on my own and assisted and advised clients in the succession planning, transfer of wealth through family trusts and wills, etc. So the journey has been a pretty interesting one with a variety of situations to which one is grappled with, and one has to tailor-make situations for the benefit of clients.
Wow. So let's get on to the topic for which we're having a conversation. Can you elaborate the importance of will making and the people avoid making wills, and what can be from your side people are motivated to make a will in the family at not at a later stage, but during my person is like a 65 years old, जब भी will का start करे, instead of starting early.
Okay. For starters, there are a lot of should I say misconceptions as to when should somebody draft his will. There are people who say, when I retire, I'll make my will. And even after they retire, they say, when I'm getting on in age, then I will do it. And we always keep our personal things at the back burner, like drafting our wills. And to my mind, no age is an inappropriate time. In fact, one has to make his will as of yesterday, and one can make it as early as one is at the age of 40. Why 60, 65? Because with today's life being so uncertain and one does not know the vagaries of life, will making is very important for everyone, for all walks of life who have a property to dispose.
Oh, perfect. Thanks for that. Clearing the misconception for people to start early. So now, my next question will be, what are the key components or parameters, or when a person is making a will, what are the key essentials he has to take into consideration while making will?
Okay. Well, the components of making the will is that first and foremost, the person making his will should be mentally sound, mentally fit to make his will. It should not be at a time, when one's faculties are waning. So it's when he's mentally fit to make his will. Secondly, is he has to, the will has to be dated. The will has to be executed before two independent witnesses, and the witnesses in front of before the testator. The person has to write his will in a manner that reflects his intention as to who are the legatees. Legatees may whom does he want to bequeath his properties to, and what are his properties he is bequeathing, and who would be the executor to his will. Though it is not compulsory to have an executor, but who would be the executor of his will to distribute the properties after his lifetime.
Wow, perfect. Yeah. So while making a will, does anybody has to include there people have got misconceptions like they include only the assets. What if a person has got liabilities? So what happens to the beneficiary when the father or the mother or whoever in the family is a senior person makes a will but forgets to exclude the liabilities the family owns, and what happens when the creditors come to the beneficiaries? What are the implications?
Okay. The fact of the matter is that when a person, drafts his will, he has to set out his entire estate. When I mean by estate, I mean not only his movable and his immovable assets. I also, would mean that he has to set out what are the liabilities which are forming part of his estate, which liabilities have to be discharged in the first instance from his estate, and thereafter, the properties can be distributed to his legatees. He can do one of the two, like for example, if he has a bank loan taken against a particular property and he's bequeathing that particular property to a particular legatee, he may want that particular the loan attached to that property be discharged by that particular legatee, or he can get his loan discharged out of the estate in the first instance, and thereafter the property should then stand bequeathed to the legatee concerned. So the legatees, the debts at the time of his writing his will, if they are significant in nature, have to be articulated. Else, he can make a generic clause relating to what are the debts, etc., that would need to be paid off. Another factor is some may want to look at the medical expenses which he wants to get reimbursed by the person who spends it on his behalf from his estate. So let us say if a loved one has spent a certain amount of medical expense on his behalf, he would want that to be reimbursed out of the estate.
Wow. Now let's visualize a scenario where a family has special children. What for the special children, if what kind of wealth transfer should one follow? Okay, the special child is taken care of his needs after the parents are no more in this world.
Okay, that's a very interesting question, because I believe parents should start thinking about planning for the special children during their lifetime, rather than leave it as part of their bequest under their will. So there are two things here. One is one can make a will where they are making specific provisions under their will, where they're creating a testamentary trust out of their will for the benefit of the special children, where they appoint executors, the trustees for the special children and appoint guardians in the event both the parents are not there, so that certain assets out of the estate get settled into that trust for the benefit of the special children, where the trustees will invest those monies so as to earn steady streams of income for the benefit of the special children. And the children are maybe, if they are put in a particular care home or they are looked after by the guardians, the expenses can be met out of their estate for their life. So that is one way of doing it, through the testamentary route. Else, during their lifetime also, while they are around, they can settle a kind of a revocable trust, which becomes irrevocable at their lifetime. And through their will, they can settle the assets into that trust for the benefit of their special child.
Okay. This is a scenario of a special child. There must be cases where the testator decides that he wants to donate some amount for charitable purposes. So how does one go about including them in his will?
Those are special bequests that can be made either in favor of certain specific charities or charitable institutions, or he may leave it to the discretion of the executor to, distribute a certain portion of his estate for charitable purposes under his name, where he wants to probably leave a legacy for a scholarship or a medical cause or things like that.
So for that, what kind of, is it a trust is required, or there? What are the ways by, since you said for education purposes mentioned, so trust has to be established, and who will be the trustees? Can the testator mention all those things in his will?
It's not necessary to set up a special trust. There are two alternatives one can have. One can give a lump sum donation to, let us say, you do not want to have a trust set up for in memory of the testator. So the testator may say, look, I've got a X sum of rupees and I want to give it to a particular charitable institution or a particular home, etc. So they give it as a lump sum bequest, in his memory, and that home creates the corpus out of that and runs the income from there. Or if he wants to do it, over a period of time and wants to ensure that that is something that is done on a dedicated basis, then he may direct through his will that a charitable trust be set up where this amount is settled in a trust, specifying who are going to be the trustees and how these amounts are going to be utilized on a year-on-year basis. So if it's a trust, that is one way of doing it. But if there are already charitable institutions, you may want to distribute it over a number of charitable institutions for various causes, which options you may seek to look at.
So now, Sanjay sir, in what cases a will can be challenged?
Good question. A will can be challenged if there are reasons to believe or there are suspicious circumstances surrounding the making of a will. For example, if a family member feels that the will which has been put up is a fictitious way, a forged will, because he or she feels that the deceased was during his lifetime, over the last few months of his life, he was not in a position to have made his will, and the will has been executed just a few days before his demise. Under suspicious circumstances, the will can be challenged. Or, for example, if the family members have been looking after the particular testator, but somebody else comes up with a will and tries to say that all the bequests are for him and his family. People can challenge that in the sense that they have no reason to believe as to why they have been left out when the testator had good relations with them, or if the signatures are suspected to be forged. So, and the timing of making the will is also very important. So, and then if the witnesses are somebody who are also not willing to come forward and witness, given their affidavits when the will has to go into court, a will can be challenged.
Mm-hmm. Thank you for this knowledge. Now, suppose a person dies and there is no will. So, what happens to the family members for wealth transfer? What are the implications and what are the challenges they face?
When a person dies without a will, he is died intestate. So the personal law takes over in the sense that depending on what religion he or she professes, that personal law will take over. In the sense, for example, under the Hindu Succession Act, whoever are, for example, the class 1 heirs, they will be entitled to file letters of administration in the court so that they are entitled to the assets equally. Or, for example, if there are Parsis. So it depends on, or Muslims for that matter, or Indian Christians, where, for example, where Indian Christians are concerned, if a person dies intestate, 1/3 will go to, let us say, the wife, and 2/3 will go to the children. So the point is that when it comes to intestate devolution, you'll have to go for letters of administration. But the more important point here is that it will go according to law and not according to the wishes of the testator, because the testator has not made his will.
Yes. So now, will is made. What are the next steps to be followed for the beneficiary? The wealth smoothly gets transferred in the beneficiary's name, and what is the role of the executor?
The role of the executor is to ensure that the directions and wishes of the testator are followed in spirit and in accordance with law. So, if the will has to mandatorily be probated under law, he has to ensure that a probate is granted, and thereafter one has to distribute the assets after the probate is obtained. For example, where immovable properties are concerned, a deed of transfer will have to be done to register it in the names of the beneficiaries. Where movable assets are concerned, one will need to distribute it to the beneficiaries. So technically speaking, the executor will have to open an account, get the assets, then distribute it from that account to the beneficiaries. Alternatively, what happens is, if the person concerned has made nominations and the assets are with the nominees are then directed to hand over the assets to the legal heirs.
So, what is the time and duration? Time and court fees or stamp duty is leviable for a probate? And my next question will be, is probate necessary for all types of assets for will transfer?
Probate is not necessary for certain communities as of now, and also for certain regions. For example, if there are properties of a Hindu in Mumbai, Calcutta, Madras, the provincial towns, a probate is mandatory. So for Hindus, Parsis, Jains, the probate is mandatory for those residing in those where there is immovable property in those cities. Else, a probate is not mandatory. But where Indian Christians and Muslims are concerned, there's a specific exemption under the Indian Succession Act for that don't require a probate. So those wills don't require a probate. So where a will is mandatorily one has to obtain a probate, one has to obtain that for the will to be effective.
So, like, what is the process of probate to be followed, and the duration time? What are the actions going behind for a probate to be executed? And once a probate is completed, what does one receive, which someone has to use that for will transfer?
Yeah. So generally, a probate would generally take typically about 9 months to a year for a probate to be granted. And what is a probate? Probate is a grant of the seal of a court saying that the particular will which has been put forth has been proved that is the last will and testament of the testator. So that is what the probate would mean, which will be a conclusive proof of that will. So one can rely on that will. For example, if there's a purchase of a property, he would ask for whether there is a probate in respect of the deceased, because the heirs would have then given their consent to that will. So he doesn't want to have himself open to challenges otherwise.
Is probate faces challenges like a will faces challenges? So what happens if a probate is being challenged?
Well, a will can be challenged, and if a will is challenged, it takes years. A probate generally is not challenged unless the circumstances under which the probate was granted were, should I say, fraudulent or behind the back of the court. So what happens is, it goes into an appeal in court, and it could take a whale amount of time for one to get the the matter, the award granted or dismissed, as the case may be. So, and what happens is that if a will is challenged, or probate will is challenged specially, then the properties get locked in disputes for years.
So, okay. So my next question will be, Sanjay sir, what are the common challenges faced during wealth transfer and how they can be mitigated?
The common challenges are if there are no nominations in the first instance. If there are no nominations, one has to go for either letters of administration or succession certificate, assuming that there is no will. So one has not, made out his nominations and died without a will, then it is, one has to obtain these succession certificates and letters of administration, which typically take that same process. So that is one aspect of it. The second is, at times when a probate is not required of a will, especially when it comes to transfer of immovable property, registrars are hesitant to effect the transfers unless probate they see a probate or a grant of a probate order. So unless a will is registered, though registration is not compulsory where wills are concerned, people prefer to have their wills registered from that perspective. So that authorities can take cognizance of a registered will rather than an unregistered.
Okay. So now, Sanjay sir, what do you advise your client for an effective estate planning?
This is very specific for each client. It depends on a number of factors. It depends on his or her profile, his or her asset profile, the family situation, family dynamics, where the assets are located. For example, he may have he or she may have special children, or may have children who are studying abroad, or he may have old parents, or he or she may have a number of children and a number of assets. There may be business assets, there may be assets sitting abroad. So there are a number of factors which need to be considered while developing an estate plan, should I put it? Because not while the will is the simplistic tool in estate planning, there are other methods by which one can do it. Like, for example, if he wants to have a trust in place for the benefit of his family, or there are business assets concerned. So it depends on each situation as to how he wants to do the transfer.
Okay. Now suppose a family has NRIs staying abroad for a couple of years, and they are the beneficiaries, one of the beneficiaries for the properties. So what process steps one the NRI has to take for the property, the asset gets transferred in his or her name?
So if the legatees are abroad, there are certain under the automatic route, up to $1 million per year can be transferred to him or her. So that is one if it wants to be transferred abroad. But there could be situations where he has bequeathed the property to the which is situated immovable property situated in India. So it depends on whether the person wants the property to be, or rather, let us say, movable assets to be remitted abroad or retained in India.
Okay, good. Now there is a scenario where the wealth is transferred to the beneficiary, and he wants to sell the asset. So how is tax calculated in such scenarios?
If a beneficiary has been, he has received a legacy of, let us say, an immovable property, and he has received it in his estate, and thereafter he wants to sell it. So the under the Income Tax Act, the period of holding which the previous owner had, he will get the benefit of it. And the cost which the previous owner had, he will get the benefit of that. And he'll be able to sell it. And for example, thereafter, he will have to add the indexation, index cost, etc., and then pay capital gains on that.
Yeah, thank you. Now, Sanjay sir, can you discuss a memorable case where your expertise in succession planning made a significant difference?
Well, there may be a number of cases where I cannot point out, not memorable cases, there are a number of cases, but there was an instance where a will was challenged, and the parties decided that in the interest, because the asset profile was substantial in nature. So rather than get it locked up in court, both parties realized it makes sense to sit across the table and sort things out. So they had a family agreement. They went out having release deeds and letters of administration done, because the will was in fact done, when the testator was not having sufficient mental faculty. So in the interest of peace and harmony in the family, they decided to, divide the assets amicably.
Wow, wow, that's superb. So now, Sanjay sir, who has influenced you from the legal world in terms of estate planning?
Uh, well, there's no one person who influenced me in terms of getting into estate planning as such, but having handled estate planning related in my career, and my past experience is why I got into estate planning, which I find to be a very fascinating subject, because it helps people to resolve things amicably well during their lifetime and to avoid family disputes later. Yeah.
Okay. Now, Sanjay sir, how do you stay updated with the latest legal and regulatory changes affecting estate planning?
Well, a number of you know laws are involved in estate planning, be it tax, FEMA. Uh, you've got succession laws. There are late Supreme Court case laws on uh, you know wills and facets surrounding that. And so the thing is, in today's age where you have information at your fingertips, you have to stay updated, with what's happening around in terms of, being updated with the latest laws relating to your subject.
Wow. So my last question for your professional journey will be, what advice would you give to young professionals aspiring to specialize in succession planning and estate law?
As I keep saying, it is the passion, perseverance, and hard work that is required to be done, for one. Secondly, they have to have that deep understanding in the subject. So, for example, where estate planning is concerned, you need to have a perspective of the family dynamics, the business dynamics, as well as the laws surrounding those particular things. So there are a number of facets. So the thing is, it's like something that can be done overnight. It requires a bit of experience to. So they have to be patient and be persevering in terms of having a deep knowledge in terms of things like tax and structurings, etc. So the point is, being constantly updated and innovative is the key.
Very good, very true, very true. So continuing conversation, let's go to the next round, the personal round. So can you share a bit about your family and how they've supported you in your professional journey?
Uh, well, I come from a family background where my father himself is a lawyer and he was an ex-judge. So he was one who largely influenced me in terms of joining the legal profession, though it was not that it was his direction, but the manner and the passion with which he worked as a lawyer, rubbed it off onto me so that I got into this line. Uh, my my wife also is a lawyer, and she got into it to assist me in my journey too. So they were my wife, my mother, and my father were the influencers, I would say, to in my journey. as of date.
Wow. So, Sanjay sir, you're dealing with different types of people day in, day out. How do you maintain your emotional equilibrium?
Uh, by being, should I put it this way, that one has to be dealing with things in a professional capacity. So sometimes the emotions run high, especially when there are family disputes. I've had a case where, there were heated exchanges in my office by the family, and you have to stay neutral and stay independent and get to the issues which need resolution. Sometimes the client may just want to let out their concerns to you. So you have to be an avid listener to them rather than advise them. So and especially when it comes to things like estate planning, it's a very personal issue. Sometimes clients are also uh, either confused, or they get emotional when it comes to things like writing their wills. So one has to look at it from a very neutral perspective while encouraging the client to do as per his desires. Yeah.
Wow, perfect. Perfect. So, Sanjay sir, what do you do in your during your weekends?
Uh, Weekends or on a Sunday? Well, I mean, I just unwind and relax. If I get a chance, I watch a movie or listen to music. Spend time with my family, more important.
Are you involved in social activities?
Social activities to a certain extent. I am, involved with certain charitable organizations. So as and when required, I contribute my time for the for the support of those organizations.
Wow. Mhm. Any travel memorable experience you like to share with us?
Yeah, in fact, I just came back from a holiday from Europe, and what I saw was that people out there, they work Monday to, let us say, Thursday evening, Friday, defined timelines, say a 9 to 5, 9 to 6, and after that they are the restaurants and their pubs and the bars, kind of thing like that, or they go to the countryside. What I mean to say is they have a defined work-life balance. They they work hard, they party, they enjoy themselves. So that keeps them motivated throughout the week, rather than working all days of the week, no matter what. So the lesson I learned is that one has to strike a work-life balance, notwithstanding the fact that we are in a profession which is demanding in nature. And I guess all professions are demanding in some way or the other.
Yeah, very true, very true. So, which book or movie has influenced you, Sanjay sir?
Uh, Good question. Which book or movie? Uh, there may be a number of such movies which I have seen, but no one. I can't name any one as of now.
Okay, it's all right, it's all right. Uh, from your bucket list or wish list, which is on top priority, like you'll have to do in 2024?
I beg your pardon?
From your wish list or bucket list, which like to complete in 2024, which is on priority?
2024. Okay. Um, what I would like to complete. Um, complete a few more engagements, client engagements, try and do another travel, but time will not permit me to do that. Have another holiday, which I don't think I'll be permitted to do so.
Okay. Now, any hobbies or creative pursuits you have continued from your early days?
Well, it's music, which I listen to a lot of music. I go for theater for some plays. So generally it's more of art and culture and music. It's something that I like looking at.
Wow, interesting. So my last question, describe Sanjay in one line.
Approachable, amicable, friendly, persevering, and solution oriented.
Wow, powerful, powerful. So we go to the rapid fire, the fun round. Are you an early bird person or a night owl?
I'm an early bird, but sometimes I also do late nights as well.
Okay. Uh, last play you have watched?
Last movie I have watched.
Play, movie, whichever.
Last movie I have watched. I passed this one for the time being.
Okay. Your go-to stress relief activity?
Listening to music.
Okay. Most memorable moment in your career?
Most memorable moment in my career is qualifying as a chartered accountant and getting my sanat
Wow.
as a lawyer.
Wow. Your favorite holiday destination?
Europe.
Favorite food dish?
Chicken biryani.
Wow. Okay. Tea or coffee?
Coffee.
Okay, let's raise a toast.
Yeah.
Best piece of advice you have ever received?
Best piece of advice I ever received. Stay patient and persevere.
Wow. So, Sanjay sir, you handled very well. So you get this copy of ebook, which is authored by me and autographed, Shaping the Gen Z Lawyer for Future. Do go through and give your inputs when you get this copy. So,
Thank you.
friends, we are having a conversation with Advocate Sanjay Rego on a Saturday afternoon. He shared lots of insights on the importance of will making and what are the different elements go into estate planning, what are the considerations, how does wealth transfer come into effect, and how to maintain uh, emotions, harmony within the family. So it's don't wait for कि you reach your retirement or you delay कि हाँ भाई आज नहीं कल नहीं. Get feared of making your will कि भाई this is my last day. Nothing. There will be changes. You can keep revising your wills. There you are what do you say creating your leaving a legacy. Do watch the episode. There are a lot of insights on will, trust, and probate, which is very essential for families to follow and take steps which will help you. And Advocate Sanjay Rego is a go-to person for executing, planning your estate wealth transfer. And this episode will be published on the YouTube channel, the Koffee Conversation Show, where we have 150 plus episodes with different subject experts. Enjoy your Sunday. We meet again with another guest speaker with another topic. Sayonara. Thank you.